More false statements being made on the campaign trail. It's May 13th, 2024, and these are your headlines. He's at it again. After being criticized last week for lying about the House's impeachment of Attorney General Ken Paxton, embattled State Representative Frederick Frazier is being called out for now dishonestly whitewashing his own legal troubles. Frazier has faced nearly 2 years of legal battles surrounding an incident in which he impersonated a code compliance officer and ordered a local business to remove his primary opponent's signs. The indictment on these charges led to his dishonorable discharge from the Dallas Police Department. Late last year, Frazier pled guilty to 1 count of criminal mischief, which is a Class C misdemeanor, for vandalizing campaign signs. He also pled no contest to 2 counts of attempted impersonation of a public servant, which is a Class A misdemeanor. And as part of his plea deal, he was offered deferred adjudication, which means the charges won't remain on his criminal record. Last month, Frazier was also discharged from his probation. That's not what he's telling voters, though. In a social media post from a few weeks ago comparing himself to former President Donald Trump, Frederick Frazier announced that the case had been, quote, dismissed. Now, a recent article by the local news station WFAA up in the Metroplex says that's not true. They wrote, in a tweet posted on X late last month, Frazier said his case against him had been dismissed. This isn't quite the case. While Frazier's probation was discharged and his record will be cleared, he still pleaded no contest to the 2 Class A misdemeanors for impersonating a public official and also pleaded guilty to a Class C misdemeanor charge for criminal mischief, for which he was fined $279, court documents show. The cases against him were never dismissed, despite Frazier's framing of the matter. Frazier did not respond to a request for comment, by the way, on WFAA's depiction. The piece is the latest instance of Frazier being called out for being dishonest. Last week, Frazier defended his vote to impeach Attorney General Ken Paxton by falsely claiming that Paxton's office refused to take part in the House's investigation, which Paxton called a complete lie. Frazier now faces a runoff election on May 28th against opponent Carissa Richardson. Early voting in that runoff and all the primary runoffs across the state begin next Monday, the 20th. 2 Denton Independent School District administrators facing criminal electioneering charges had their court appearances delayed. They were set for today. Jesus and Lindsay Lujan, a husband and wife who are both Denton ISD employees, were scheduled to be arraigned this morning in Denton County criminal courts. Their hearings were rescheduled to June 18th, according to a court officer. The Lujans are each charged with unlawful use of an internal mail system for political advertising, a Class A misdemeanor punishable by up to 1 year in jail and a $4,000 fine. The charges mark the first time Texas school officials have been criminally prosecuted for using public resources to electioneer. Both were indicted on April 2nd after local voters submitted affidavits to the Denton County District Attorney Paul Johnson that alleged that the Lujans engaged in criminal election interference. They have evidence that the Lujans used Denton ISD's email system to incentivize employees to vote in the March 5th primary for anti-school choice Republicans. The email sent to school staff by Lindsay Lujan, who is Denton ISD's Director of Special Programs, and by Jesus Lujan, who is the principal of Borman Elementary, offered to, quote, provide coverage for all school employees to go and vote in the Texas Republican primary for candidates who, quote, support public education and school funding. Now, Texans regularly report school electioneering activities, particularly during bond and tax increase elections, but no government school officials have ever been criminally prosecuted up until now. State senators, meanwhile, are scheduled to meet later this month to evaluate current electioneering laws and to make recommendations to strengthen these laws and put a stop to illegal electioneering.
What are the important things out there in Texas politics and Texas news that matter to you, and what can you do about it? That's what we want to bring you with the Luke Macias Show on a weekly basis for 20 to 30 minutes. That way you can get the information and go do something for the rest of your week. I look forward to coming to you every Wednesday.
After a former Democrat sued the Tarrant County GOP and its chairman, Beau French, in an effort to become part of the party's governing board, the party is asking the court to dismiss the election contest. Now, some background. During the primary election in March, Chris Rector won a seat as a precinct chair. Precinct chairs are members of their county party's executive committee, which assist in governing the local party. But Beau French declared Rector to be ineligible for the position after it was discovered that Rector was affiliated with the Democrat Party. Soon after being declared ineligible, Rector filed a lawsuit against French and the party. On Sunday, French and the Tarrant County GOP responded to the election contest, saying the case should be dismissed on the grounds that the contest was untimely. The Tarrant County GOP is not a proper party, and the court lacks jurisdiction to interfere with the party's right of association. In the Tarrant County GOP's answer to the contest, they state that Rector seeks to use his election contest to invade the Tarrant County Republican Party's freedom of association so that he can work to destroy the party from the inside. The filing states that Texas law does not recognize political parties as proper contestees in election contests. Accordingly, inclusion of TCGOP in the suit is an error, and this court is required to dismiss this action against the party. For more of today's stories, go to TexasScorecard.com.